Ready, start. The petitioner has specifically asserted the fact that the petitioner was never served a charge sheet containing a statement of charges along with the adverse material which was relied upon by the respondents dash authorities while passing the impugned order. Full stop. The specific pleadings in the writ petition in this regard are not traversed by the respondents in their counter affidavits. Full stop. Failure to serve a charge sheet disclosing charges with material particulars upon the petitioner disabled him from tendering an effective defense of his case. Full stop. The omission constitutes a grave violation of principles of natural justice. Full stop. The vague nature of the charges vitiates the disciplinary proceedings. Full stop. The second fault line in the impugned orders is that they were passed on the foot of an ex parte inquiry. Full stop. The pleadings in the writ petition in regard to the inquiry being conducted in violation of principles of natural justice to have not been traversed in the counter affidavit. Full stop. The inquiry against the petitioner, which culminated in the impugned orders, was passed by adopting a procedure not known to law. Full stop. Attention has been called by the respondents to the certain proceedings chart appended to the counter affidavit to contend that the petitioner participated in the inquiry proceedings. Full stop. However, in absence of pleadings in the counter affidavit in regard to the participation of the petitioner in the inquiry proceedings, the document is of no avail to the respondents. Full stop. Even if the aforesaid documents are taken in the face value, the pleadings of the respondents dash university do not disclose that the said documents were served upon the petitioner or that the petitioner was noticed on the aforesaid adverse material at any point in time. Full stop. The said adverse material, including the report appended to the writ petition, became the basis of punitive action against the petitioner. Full stop. The prejudice caused to the petitioner by the said procedure followed by the respondents is beyond recall. Full stop. The submission that the inquiry report too was not served upon the petitioner, precluding him from refuting the same, shall now be considered. Full stop. The counter affidavit boldly asserts that the said inquiry report was sent to the petitioner along with the suspension order. Full stop. There is no proof of service upon the petitioner. Full stop. However, in the interest of justice, the court has perused the report. Full stop. The said report merely references some students who had mentioned the name of the petitioner. Full stop. It is noteworthy that the inquiry report does not discuss the nature of the statements and the manner in which they indicted the petitioner. Full stop. Indictment of the petitioner on the basis of the inquiry report is perverse. Full stop. In this way, in the absence of such consideration, the inquiry report is vitiated by violation of principles of natural justice and non-application of mind. Full stop. The impugned orders of punishment passed on the foot of the said inquiry report are consequently perverse and illegal. Full stop. There is another aspect of the matter. Full stop. The scheme of punitive action in an institution of higher learning is an indispensable feature of its administration. Full stop. The penal regime in a system has to amalgamate essential elements, full stop.